for your patience.
I just wanted to ask you about your Loper-Bright point and the degree of discretion that the Sentencing Commission has here. I'm going to state it, and then you tell me if I'm understanding your point correctly. You don't dispute, Justice Kavanaugh pointed out that the terms extraordinary and compelling are capacious terms. And so the Sentencing Commission does have some discretion within words like that to enact policy statements. Right. Just
correct.
Okay. I'm getting to the point I think that you want me to. Your point about Loper-Bright is that discretion has to happen between certain goalposts, and the fact that the First Step Act has imposed a rule of non-retroactivity means that the Commission has exceeded the limits on its authority. So it's not that it doesn't have a lot of discretion, but here it's bumped beyond that.
That's exactly right, Justice Barrett. And I think one problem with their position, and I think it's been well illustrated in the other arguments in this case this morning, is there's really no limiting principle to what they're saying the Commission could do. They are, I admit I'm a little confused as to what their answer is to the hypothetical where the Commission just decides to allow courts to disagree with mandatory minimums. But I think the reason they're not giving you a clear answer that the Commission couldn't do that is because it logically torpedoes their argument. Because in their view, the Commission can say anything it wants as long as it hasn't expressly precluded sentence reductions. But of course, a mandatory minimum like the one in 924C just says the defendant, if you look at the language there, that it just says the defendant shall be sentenced to a term of no less than 5 years.
So